has been and will have to always remain safety. Now, we want to help to be a partner in driving technology forward. But a lot of times people get frustrated with us because they feel like we're moving at a snail's pace. At the break, we were discussing the time period it takes, for instance, right now to get waivers processed. Well, again, you know, these waivers under Part 107 are a new issue for us. You know, we've done waivers for conventional aircraft for years. You can go into a FSDO and get a waiver for a conventional aircraft. For us, we're trying to validate the mechanisms and the methodology and means of mitigation. And so for us, our paradigm can't change away from safety. But it doesn't mean we don't open our ears, because the partnership for us to understand the new technology and to apply it safely and to use our rules is important. We made huge steps going forward, and 107 probably is the most dramatic. Because before that, we didn't have any regulations that were specific to unmanned aircraft. We were trying to make a square peg fit in a round hole. And on top of that, we also had various dictates and various limitations that Congress placed on us. And I know it may not be the school of modern thought all the time, but we take our directions from Congress very seriously. And so whenever we've done any of our changes, any of our programs, we have to stay within that statutory structure, what we're authorized to do and what we're limited. So we'll get into that in a little bit more detail. While he's playing with that, I'll talk about a few things that I was going to mention. So I emphasize partnership, and that's very big for us. One, because we're dependent on the people outside of the industry to bring the technology to us. I mean, we're not funded to develop the technology for the most part. I mean, we have our tech center and we help fund certain research. But that's not our primary mission. So we're dependent on y'all to bring the technology forward to us. The development of technology, and Jay, I think, described 3 or 4, for instance, that we refer to as pathfinders. You know, we're going to be the people that are going to be at the cutting edge of this, but they're not going to be the only ones. CNN, I think, is the one looking at the over people thing. The NSF's looking at the out of line of sight operations. All this is going forward in a partnership with us. But besides just specific programs, we're like that's very, you know, goal oriented for a specific project. We have some broader partnerships with the UAS community that we're pursuing. And this is a challenge we face. So we're going back to some methodology we use to man aircraft and some things we're very, very proud of, and I'm going to relate it in our compliance philosophy later on in the presentation. 10 years ago, they created a commercial aviation safety team, and it was a partnership between the industry and the FAA. In 10 years, conventional aircraft accidents have declined by over 80%. 80%. I mean, I dare you to find a government program that's worked that well. But in fairness, it's not just a government program, it's a partnership. Well, that's what we're looking at. We want to create and use the same sort of model for unmanned aircraft. And so the administrator has announced that they're going to have a unmanned aircraft safety team that's going to be modeled after this commercial aviation team. you know, we believe it'll pay great dividends. Don't need to go through a lot of this. I think Jay mentioned it. All of y'all understand. I'll emphasize for regulatory purposes that there is a distinction. You know, for us in the FAA for years, we looked at the aircraft. It was a single airframe. The models changed for us, and now we have to look at things as systems. And that may be important, particularly as people seek to get airworthiness certificates, because we're not only going to be certifying the airframe, we're going to be certifying the system as a whole. I know that people that are passionate about unmanned aircraft, many of them have been frustrated with the FAA. And many of them felt like, hey, is this really the FAA's business? It's been tested now on some court cases. We're very confident in our jurisdictional basis to regulate the aircraft. We have general authority to promote safe flight of civil aircraft and air commerce. People say, well, what if I'm not doing something commercial? That's not what air commerce means. That's very much a broader term. We also have the authority to protect aircraft, but also people and property on the ground. And that was kind of the rub, I think, with some of the initial unmanned aircraft operators that were taking us to task. They're saying, look, we're not endangering aircraft. You know, we can go out here and do what we want. And Congress has specifically delegated authority to us not only to protect the national airspace system, but to protect structures and property on the ground. We have our sovereign authority is to regulate the airspace. And when you look at it, some of the arguments were, well, if you're not in the typical commercial airspace, do you have authority to regulate it? Well, besides the protecting property and people on the ground, if you want to think about it conceptually, you know, unmanned aircraft now are changing how we view what is navigable airspace. Now, there is a school of thought, you know, and I'm not suggesting it's a correct school of thought. Some people suggest, well, if you hit an line of sight at low altitude, that's not interstate commerce, and so the FAA doesn't have authority to regulate that. So we can do what we want. There is case law that says if you can affect interstate commerce, that we have the authority. So I think most of these challenges to jurisdiction have been put to rest. Not that people won't still try to litigate it, I'm not suggesting that, but we're pretty comfortable that, yea, verily, you know, we are the regulatory agency that has authority to regulate unmanned aircraft. Now, the challenge is that it's very much different from manned aircraft now. In part, I think, because of the simple explosion in the number of these aircraft out there. I think they mentioned, what, over 500,000 now have been registered, and that's the ones that have been registered. There's a lot of concern because of where they're operated. Unlike manned aircraft that have to take off generally from a fixed location, and there's a finite number of manned aircraft. Now you have it literally could take off from the back of a pickup truck or someone's backyard. And there's the privacy aspect. So now state and local governments are starting to get much more engaged and interested in the regulation of unmanned aircraft. To a large extent, most states and municipalities have not tried to do that with manned aircraft. Some have had laws on the books, but they generally didn't try to enforce them. And in some cases, they dealt with noise. They were trying to regulate aircraft noise. Well, our concern for manned aircraft for years has been a concept called preemption. And that concept says that, you know, the FAA is the only one that can regulate how people operate aircraft. And in part because we want a uniform set of rules. You know, we don't want people having different operating procedures when you fly over Toledo, and then when you get to Cincinnati, you've got a different set of rules. to follow. So there's been a reason for that. And the courts have upheld that for decades. Again, we've got a new paradigm to deal with, and this has not been tested out. And in fact, you know, what's different is that because of the sheer number of municipalities, and state governments, local governments, and counties and parishes, and the number of aircraft, the likelihood of a diverse group of regulations and statutes and cases that may come up where other people will try to assert, you know, this preemption, or the state municipality will try to oppose this preemption concept, leaves us with a new frontier. We do not know where that's going. But what we've tried to do now is be proactive. We have gone through a cataloging process from the General Counsel's organization of the various state and local governments to the extent we could. And we're also trying to work with the state and local governments. I'd like to tell you and predict, you know, how this will come out. We're recommending constant consultation with us. We want to work with them. But we can't control where the litigation may go one day. In the end, it may be that this is going to be decided by Congress, because again, we're being faced with something totally different than we've seen before, and it may be up to Congress to call the shot on just how far a state or local government can go as far as regulation. I can tell you this, there's some areas very clearly the state and local governments, no ifs, ands, or buts, can regulate. And it's not in how you operate an aircraft, but it's what's called the traditional police powers of the state or local government. So, for instance, the city of Anchorage can say, this area of the city, on the surface, you cannot launch an unmanned aircraft from it. They own the surface, they regulate the surface, so they can say you can't operate from there. Once you get airborne, how you operate it, that will be the challenge. That's the area that we're in uncharted waters over. Same thing for criminal statutes that deal with operations that where an aircraft's used as a weapon. So, you know, if you use unmanned aircraft or conventional aircraft to intimidate somebody, the state can prosecute you for that. It just so happens to be that it's an aircraft, but it's being used as a weapon, just like a baseball bat, a gun, or a pickup truck. Same thing if you kill somebody with one. If they have a negligent homicide statute, you know, that's not really regulating the operation of aircraft. That's a legitimate state interest. So there's some areas we know, whether it's unmanned aircraft or conventional aircraft, that the state and local governments can legislate and regulate in. The extent past that, we don't know yet. So the real watershed event, more than anything, has been the small UAS rule. I'm not suggesting to you that the commercial operators have presented the greatest threat to the NAS that anyone else did. That's not what I'm suggesting this is a watershed event. In fact, I would suggest, and I'm going to make clear this is my opinion, not necessarily the FAA's, that the people out here trying to do commercial operations, the people that will come to an event like this, much like the people that come to our GA training events, aren't the people that are going to be the danger of the airspace system. It's going to be the road person, you know, that gets out there, the highest risk, that don't care. You know, they're not the ones that are going to try to comply with the rules. They're the ones that are going to be the single greatest threat to the NAS. Then you're going to have a lower tier of people that probably are a lesser threat than the real roads. And that's going to be the people that, you know, they think this is fun. It is. I mean, how cool is this technology? But they're not already inculcated with the values and the things that are incumbent on people that use an air system. If you've been a pilot, or let's say you've been an air traffic controller, you understand how the system works. You develop what I would call a value system and a system of judgment that, you know, allows you to operate safely, understands the sensitivity of certain classes of airspace, communication, see and avoid, things like this. There's this lesser group of people that I say they're not out there trying to do wrong. It's fun technology, but they don't have the sensitivity about the airspace that others do. And then you have the people like you that are studying. This is an academic challenge and a safety challenge, and they understand that. And so it's those two groups of people above that are really the people we're going to have to target ultimately with our compliance initiatives. The reason I say 107 is a watershed event because we might as well face reality. There were so many people out using unmanned aircraft to take pictures for commercial purposes, to do real estate, to do different things. We knew that they were out there, but they were not in compliance because under the definition of model aircraft, they weren't doing it for a hobby. That's why that interpretive rule is important, to try to help set a standard for people to fully understand these are the categories Congress created. This is how we're going to explain they exist. So we had a lot of, I'm going to use the term technical non-compliance, but they weren't people that were necessarily creating a intense endangerment of the national airspace system, but they weren't in compliance with the rules of the statute. We eventually got the 333 process going. That allowed them to get exemptions so they could go out and operate. I don't want to get too deep into it, but what the 333 exemption process did was allow you to operate a civil aircraft that was a non-model aircraft without an airworthiness certificate. Because those statutes I was talking about, by statute, we have someone to operate has to register an aircraft. If it's a civil aircraft, it has to have an airworthiness certificate, and you have to have a pilot certificate. Well, Congress gave us that 333 authority for the airworthiness aspect, but not the pilot certificate nor the registration. The registration was easy, and despite what some people may complain, $5 in a few minutes on a computer, you can register an aircraft. It can take a little longer, I get that, but that was not the real roadblock. The problem with 333, if you want to call it that, is we could use it to excuse the requirements for the airworthiness certificate, because that's what Congress said. We're excusing this one out of the three-legged stool, this one leg, but we still had to have some form of pilot certificate. We could not go outside of what Congress requires. 107 is the ticket. That gets us out of the somewhat onerous burden of having to go through an exemption process. So this, while it may not seem like much to some people, this is a sea change in allowing people to start using unmanned aircraft. And what I would say the more traditional, if there is such a thing for unmanned aircraft, commercial purposes, non-hobby purposes that are out there. And to do it in a fairly time-efficient and cost-effective measure. Jay mentioned this, line of sight only, daylight only, no operations over people, yield right-of-way to manned aircraft, yada, yada, yada. Some of those things may be waived, as Jay mentioned. The weight limitation of 55 pounds is what I would call jurisdictional. That cannot be waived. So if you're going to fly a larger UAS, you can't use 107 and seek a waiver to the weight limit. That's still going to require exemption. Now, probably it's an appropriate time, so some of this makes sense, to explain a little bit the difference between waivers and exemptions. Waivers are an administrative tool that may be done without any type of public notice or comment, Federal Register, anything like that. And they generally can be done fairly quickly. Now, the ones we're doing under 107, at least initially, are taking longer because we don't have a blueprint for them. We haven't done these before, so it's taking a little time to work through the mitigation measures and do the evaluations. But generally, waivers can be done in a fairly expeditious process. Right now, for unmanned aircraft, they're centralized. For manned aircraft, you can go to the local FSDO and get a waiver. We're not there yet with UAS. Eventually, we hope to get there. That's the goal, where you won't be having to use a national portal and get in line with a whole bunch of people. You'll be able to go to the local FSDO and get service, but we're not there yet. Exemptions are different. They're more involved. You have to go through a formal petition. Generally, a notice is put in the Federal Register. Members of the public can object to it. Much like waivers, if you're asking for something that hasn't been granted before and there's not a blueprint, they generally take longer to be evaluated. But then exemptions, if you're in this and you're looking at things, getting things that need an exemption, you can plan that that's generally going to be a longer process than getting a waiver. Not always, again, you know, with the exemptions, if it's one that we've already granted and you're just basically Xeroxing what somebody else done, it may go fairly quickly. But there is a distinction between those two processes. Yeah, I'm not going to be redundant with Jay's presentation, but again, if nothing else, you can see the certification requirements to have authority to operate, much less than even a recreational, conventional manned aircraft pilot. The 333 folks can still use their exemptions. There may be advantages to having an exemption for 333. Again, things like the weight requirement. Public aircraft operations are still a qualifying operation. And again, they have some advantages. They're generally not, I would say not as easy as 107. Jay's processed these things for years. It can be a very involved, time-consuming process. They do have drawbacks. And so as an example, a public entity that's operating as a public aircraft cannot do things for compensation. Hope that's nothing I did.
No,
That's not my ankle bracelet monitor going on.
Again. Yeah. Nope, it's nothing I You're good.
Okay,
Yeah.
okay. In any event, so there's limitations on public aircraft operations as far as getting compensation. Now, I'll try to give you an example, and not to try to turn this into a UAS law school class, but it'll give a little bit of understanding why people pick and choose between these options. So, if you're a university, you otherwise qualify. Not all universities do, but you otherwise qualify as a governmental entity, and you're conducting a unmanned aircraft operation. It's a public aircraft operation. You cannot take compensation to do that. You would have to go into either Part 107 or get an exemption or get an airworthiness certificate to do that, which is even more time-consuming and expensive. So, Boeing Corporation comes to UAF and they say, we want you to do this work for us, operate this aircraft, we're going to pay you X amount of money to do it. And you're doing it for us. That's not a public aircraft operation because you're doing something to advance the commercial purposes of Boeing Aircraft Company. Now, we can take a different example. For instance, where Boeing Aircraft says, you know, we want to see the industry succeed. We're going to dump $5 million in a grant to UAS to develop this technology, but we want it open to everybody. Put it on the internet, anybody in this room here can grab it and use that technology. that may be a public aircraft operation because you're doing something to benefit the public. You're developing something as a governmental entity and not proprietary data. At the end of the day, what you can see is and it may appear Byzantine right now, but what this does, at least under our current structure, is it gives flexibility for people to do different types of operations. And so, you know, the operator can choose, you know, where's my compensation coming from? What am I developing? What am I putting out there? They can pick and choose what better fits their business model or the need of whoever they're dealing with. And we're stuck. Model aircraft. This is probably where it all got started. Our first challenges was to model aircraft. Now understand, we didn't define model aircraft. Congress defined that. It set out the standards and told us, okay, you're gonna treat these aircraft a certain way. You're not gonna regulate them like you do other aircraft. You're not gonna regulate them like you do other unmanned aircraft. But as anything, with Congress, you know, it's just realistic. When they write statutes, they can't get down into the weeds of every little thing. They tend to use more generalized language, and then it's up to us to apply it. This interpretive rule, that's what that was for. This was for us to interpret and try to provide, I would say, some meat on the bones as congressional definition. And I'm going to take the opportunity with two folks in our headquarters, Charles, who's on the phone, and a guy named Dean Griffin, who worked on this and spent a lot of time. We have had some disgruntled people that have tried to challenge us in court. We're pretty comfortable in how it's come out. I would suggest if you're doing things as a model or hobbyist, you go online and read this. It's very valuable information, and I think that was what you may have thought was the advisor circular.